In Vietnam, debt recovery does not always start in court. Often, it starts with one document, a legal demand letter. When done correctly, it can unlock repayment, reopen negotiations, and reset leverage, without filing anything. But when done poorly, or sent too late, it becomes just another message the debtor can ignore. In this video, we explain why demand letters can be powerful in Vietnam, what makes them effective, and the situations where they realistically do not work, so your first move is strategic, not emotional. A legal demand letter is a formal written notice sent to a debtor requesting payment or performance under a contract. It typically states the amount owed, explains the basis of the claim, sets a clear deadline, and outlines the next steps if the debtor fails to respond. In Vietnam practice, it is often the first strategic step before litigation or arbitration, and many contracts require formal notice and a cure period prior to escalation. In other words, the letter is not just communication. It is a structured legal position and a documented timeline marker. Many foreign companies send reminders, disguised as demand letters, polite, vague, missing deadlines, or written only in English. Those messages rarely move the debtor. A proper demand letter is different. It makes a formal demand with a clear deadline and defined next steps. It references the contract terms, attaches or indexes supporting documents, and is drafted in a tone that is firm and professional, without threats or emotion. When the debtor reads it, the message is simple. The creditor is organized, the claim is documented, and the next action is already planned. Demand letters work because they create clarity and credible escalation. First, they help establish proof of notice, that the debtor was formally informed of the breach, the amount claimed, and the deadline to cure. Second, they anchor timelines. When the debtor ignores a properly delivered demand letter, the creditor can escalate with a cleaner record. Third, they often shift the negotiation psychology. Many debtors ignore informal follow-ups, but respond when they see a structured legal position supported by evidence and counsel involvement. It is not pressure for pressure's sake. It is clarity plus consequences in a lawful framework. A strong demand letter typically includes 5 core elements. 1. A clear statement of the debt amount and how it is calculated. 2. The contractual basis, the relevant agreement and the specific clauses involved. 3. A factual timeline of breach, delivery or performance, acceptance, invoicing, due date, and non-payment. 4. A specific deadline for response or payment, often expressed in working days. 5. The next steps if the deadline is missed, such as negotiation, arbitration or court proceedings, and enforcement steps after a decision, as permitted by the contract and applicable law. For foreign clients, bilingual drafting is often helpful to reduce misunderstanding and ensure the debtor's decision-makers fully understand the claim. A demand letter is only as strong as the ability to prove it was delivered. In Vietnam, proof of notice can be important if the dispute escalates. That is why we use verifiable delivery methods, courier with delivery records, and official email channels that can be documented. The goal is practical. Preserve evidence of delivery and receipt, reduce "we never received it" arguments, and keep the case moving. A good letter with weak delivery creates avoidable risk. A good letter with clean delivery creates leverage. Demand letters are most effective when used early, before the debtor has time to restructure, move assets, or disappear. They work best when the debtor is still operating, still reputation conscious, and still capable of paying. They also work best when the creditor has clean evidence, a clear contract, clear performance records, and clear payment terms. Finally, demand letters are often more effective when issued through counsel, because it removes emotion and signals procedural readiness. The objective is not to intimidate, it is to make settlement the easiest rational option. Demand letters have limits. They tend to fail when the debtor is already insolvent, already inactive, or has no meaningful assets. They also fail when the creditor sends multiple, final notices, with no follow-through, training the debtor to ignore deadlines. And they fail when the claim itself is weak, missing documentation, unclear delivery, or ambiguous contract terms. A demand letter is not a routine step. It is a trigger within a broader plan. If the plan is absent, the letter loses power. A foreign supplier faced a significant unpaid invoice. Emails were ignored and communication stalled. After reviewing the contract and evidence file, we issued a structured bilingual demand letter with a clear deadline, document index, and a defined escalation roadmap. Shortly after receipt, the debtor re-engaged and the matter was resolved through a structured settlement, without a court filing. Details adjusted for confidentiality. The result came from discipline, evidence, clarity, and timing. If your company is owed money in Vietnam, don't start with vague emails and hope. Start with legal precision and a documented strategy. Let LTS Law issue a demand letter that is evidence-led, procedurally ready, and designed to move the debtor toward payment or settlement. Contact us at lts.com.vn to request a bilingual legal notice. Because in Vietnam, one letter, done right, can achieve what months of reminders never will.